Okay. All right. Again, thank you for joining us. Today is already September. It's September 9th, and we'll be going over specifically things for landlords to focus on and new property owners to focus on as it pertains to our local rent stabilization law in Mountain View, which is the Community Stabilization and Fair Rent Act. And for short, we call it the CSFRA. Okay, so just before we get started, as a reminder, city staff, me, is not able to offer any legal advice, but we can go over facts and best practices, and we will be doing an overview of the CSFRA and a couple other state laws. Before we get started, I'll introduce myself. My name is Andrea Kennedy. I work for the Housing Department and specifically the rent stabilization division for the city of Mountain View. All right, and I don't think I go over it later, so let me just do sort of a process of how the workshop will work. We'll go through kind of different sections. I'll be sure to stop and ask for any questions, but if any questions pop into your mind, you can go ahead and just type them in the chat box or in the Q&A, and you can also raise your hand in your computer if you want to ask your question out loud. So any way you want to sort of participate is okay with me. So we'll start with CSFRA basics. And when we're talking about the Community Stabilization and Fair Rent Act, we're talking about a voter-approved measure. So it went on the ballot, and the citizens of Mountain View voted and passed. This measure was called Measure V, if anybody remembers it. And it's meant to stabilize the community by reducing housing turnover in certain rental units. And we'll talk about which type of rental units we mean. But it has sort of three main components. Number one, it's meant to stabilize the rents. So there are certain rent caps in the city. It also provides eviction protections for covered rental units. And then thirdly, provides a fair rate of return for property owners on their investment property. And they do that through a petition process. So who's covered? So there's two types of coverages for the CSFRA. We have fully covered units and partially covered units. And our fully covered units will be buildings that were built before 1995. And for those fully covered units, they have to abide by both the rent stabilization section, so those rent increase limits, and the eviction protections. And then partially covered rental units are those built between 1995 and when our law went into effect, which was at the end of 2016. And for those properties, only eviction protections apply. They don't have to follow the limits on rent. And that's just because a state law was passed in 1995 that prevents rent stabilization for buildings built after 1995. So that's why there's a difference there. Alrighty, so this is on the left side is just sort of what we already went through. So we have our fully covered properties built before 1995, rent increases, and eviction protections. And you would have had to do a rollback at the beginning of the law if you had tenants that were in your unit before 2016. And if there are any questions about that, we can talk about it a little more. But most people should have done that already or already have known about that. And then we have our partially covered units that are between February 1st, 1995 and the end of 2016, just cause eviction protections. And then anything built after December 23rd, 2016 is not covered at all by our local rent stabilization law. So if you have tenants, though, you still have to follow any sort of state laws that may be in place, especially just general tenant landlord laws. It would be good to be aware of those, but it wouldn't follow Mountain View's CSFRA. We also have some properties that are fully exempt. Single-family homes that are on their own parcel of land, so their own lot, they are fully exempt. Condominiums, companion units like ADUs, duplexes are exempt. Hotels, hospitals, and any fully government subsidized rental properties. So that does not include Section 8. Section 8 can still be covered, but if you have a 100% affordable rental property, that would be exempt. Okay, now we'll look at sort of general compliance with the CSFRA. So if you're a property owner, there's a couple things that you must always keep in mind. The first one is that the city or our rental housing committee, who is sort of like our mini city council that um, passes rules and regulations for the CSFRA. So every year they set a budget, and with that budget comes the annual rental housing fee that is then sent out to all of our landlords in an invoice at the beginning of January every year. So they have already passed their budget for next year. So just looking ahead, there is going to be a new fee coming out in January of 2026, and it will be $130 per unit. And if you haven't paid last year, that was $120 a unit. So you'll sort of see that there. Um, so that goes out every January. It's due by January 31st of every year. And there is a 4% per unit per month late fee on any unpaid fees after January 31st. So that adds up pretty quickly. So our staff is sure to try to send out as many reminders as we can to make sure everybody knows that that's coming up. The other thing to keep in mind is there is a annual rent registry that has to happen if you're a property owner. So you must register your property again every January. So we actually open this up mid-December, so kind of gives people a head start. So you have a little bit over just then the 30 days. But we'll open it up. We'll send out postcards. We'll send out emails. We'll send things to let you know that the registration period is open and you can go online and update your information. So you must put in contact information for the owner and the manager. You must also put in unit information. So we're looking at things like how many bedroom, how many bathroom, if it's vacant, occupied, and then what is the current rent. So it will ask that information every year. So you can either wait for the unit part of it to kind of update that every year, or if you just kind of stay on top of it, then by the time the new year rolls around, you just review it, make sure it looks good, and submit it, and you're good to go for the year. The one thing I will mention, though, for any contact information, you do need to update that within 30 days of, say, like a change in ownership or a change in management. And that's just to ensure that we have the most accurate contact information for the property. The other thing you can do that I'll just mention since I'm talking about the registration page is if you have any termination notices that you've issued to your tenants, banked rent increase notices, or any tenant buyout agreement notices, there is a requirement to submit a copy to the city. And you can do that through your online database portal. And it kind of will keep a very clear record of when you submitted it, what you submitted. It keeps the record clear for the city as well as for you, because you also have access to that record. So we encourage people to submit that through the portal. Makes everything a lot easier. So those are two main requirements as a landlord of a property covered by rent stabilization. Now, we do have very specific regulations talking about compliance and what happens if a property is not in compliance. And that's chapter 12 of our regulations, which can be found on our website. But it's basically saying that if property owners fail to substantially comply with the law, they are not legally allowed to raise rents on any of their units. And if they do raise rent on the unit, then a tenant would be able to file a petition to get that rent reduced. So we do encourage people to stay in compliance. So here's a high-level overview of some of the requirements to stay substantially in compliance with the law. So if you are a property owner who did not roll back their tenant's rent back in 2016, you want to contact us as soon as possible so we can sort of walk you through how to remedy that, but you would need to sort of repay back and reverse any rent increases and pay back any overpayments before you can correct that and move forward. You have to follow the proper rent increase, the annual rent increase limits. They must have paid all the rental housing fees, must have registered the property with the program, and the property must be maintained and should not have any code violations or health and safety violations on the property. So those are the substantial compliance factors that we're looking at when we are talking about compliance. Now, if a property is not in compliance with one of those things, this is sort of what the remedies are. So, of course, I mentioned already that if a property is out of compliance, there should be no rent increases given to the property or to the tenants. And if a landlord is interested in filing a petition to increase the rent on their property through a landlord petition, that would be denied because they are out of compliance with the law. So again, we do have compliance letters that go out. So we send out a first non-compliance letter to the landlord just as information, letting them know, hey, this, for example, property has failed to register. Please register the property to be in compliance. If that fails to happen within 30 days, a second notice can go out to the landlord, and a copy of that notice will go out to any of the affected tenants. So the tenants will also get a letter saying the landlord is not in compliance. If you've received a rent increase, you can contact the rent stabilization office. The next thing that I touched a little bit about earlier, but there are late penalties that will be applied to your property. So for failing to pay, again, that's 4% per month on the total balance. And then for failing to register, there's a separate fee. It's $25 per unit per month. So both fees can be applied at the same time if both of those are out of compliance. Any questions about any of that? Oh, I saw a hand, but it went away. Gary?
Hey, Andrea. Thank you so much for the presentation. Can you hear me okay now?
I can.
Awesome. Just a quick question for you regarding, I know that you start this at the end of the year and then the beginning of the year for kicking this off for the landlords. I'm in the situation where I'm in the process where I had a unit, a fourplex, right? So I'm clearly in the boundaries of this. They've been empty. I'm in the process of renovating each of them, and each of them are going to come online over a period of time. So if I bring one, I'm going to give you an honest example. Like I'm going to bring a unit online in the next couple of months. But last year year I had an exemption, right? So do I need to work with you to pay my $25 fee and kind of get that in the system for this year, and then clearly next year I have to apply, the fee for the 1 unit. I'm gonna have another unit coming online next year as well. Do I pay those fees up front for the entire year? Hope I'm asking this correct.
Yeah, so every year when we send out the invoice, we'll send it in your case for 4 units because you have a fourplex.
Yeah.
So we'll send the invoice out for 4 units. You'll get that like the first week of January. If you have any exemptions that you need to apply to the property, you'll go ahead and apply those exemptions through the portal because you can apply for exemptions through the portal
Yep.
before you pay your fee because the portal will recalculate your total based on your exemption. So if you have, say, 1 or 2 exemptions, your fee may go down because you're paying for only 2 units instead of 4 units.
Mhm. Right.
So, and then you have to apply for exemptions every year. So
Yes.
it'll just be a process you do every year.
Every year.
Yeah.
Okay, that sounds good. And then for units that are in the process of being renovated but that are not rented, is
Mhm.
there a period of time that do you still have to apply? I mean, those in theory will be rented in the future, but they're not rented at that time.
Yeah, those will not be exempt.
Those will not be exempt. Okay, so you
Right.
pay the fee. You pay the fee
You
whether
will
it's
pay the
where it's
fee.
vacant or occupied, right?
Correct.
Cool. Thank you so much.
Yeah, thank you. Good question. Okay, don't see anything else, so let's go on. So the next section, landlord rights. And I will not go into this very detailed, but here is a list of different laws that would apply to you. So I will be emailing this PowerPoint presentation out. So if you want to look those up online, you can. But you'll see our local laws. The CSFRA is on there. We have a tenant relocation assistance law in case you're ever redeveloping your property, and then sort of like uh, health and safety codes there as well. Okay, so high level landlord rights. We'll look at things that just apply for a tenant. So the idea is sort of just to go through the idea of a tenancy. So things to do before the tenant moves in, things like the screenings, the lease agreements, what is rent, and then during tenancy, rent increases, habitability, um, any reasonable accommodations, and then, in the situation where a tenant's not voluntarily leaving, but you have to use a termination notice, sort of what is the process for that, and what kind of steps you need to take, taking into consideration the just cause eviction protections we have, and then sort of how it looks like when the tenant is leaving with security deposits and walkthroughs and things like that. So that's kind of the idea of the presentation here. So looking at pre-tenancy, you of course want to screen your tenants. That's probably one of the most important things that you will be doing when picking your tenants. Oh, looks like my internet's going a little slow. If I start getting choppy, please let me know. If I, for whatever reason, have an internet shutdown, I will log back in to the webinar and everybody please log back in with me and I will start where I left off. But um, let me know if you can't hear me. Okay, so for screening, you're screening things like credit worthiness, rental history, any past evictions for the tenants, income, and then you want to make sure that you're being very intentionally non-discriminatory towards anybody who may be applying for your rental unit. Another thing, in my past life, I was also once a landlord, and the one thing I definitely made sure to do was reference checks. So I did call previous landlords and checked tenants' um, references, and I thought that was very helpful. So if anybody is new, I do recommend that. So during these screenings, you're definitely checking, names, ages of the occupants. You want to have phone numbers, prior addresses. Important to check their income, to make sure that they're able to afford the unit that they're applying for. So a copy of bank stubs or bank account information is really important. And then definitely things you want to steer clear of is immigration status, familial status, ethnicity, any sort of medical information. You want to be careful to ask anything about that. Um, so I would just steer clear of that because California and the United States have pretty solid fair housing discrimination laws. Um, So anything that could be kind of be considered arbitrary, something that a person can't control about themselves, you want to be careful of. So again, like I was mentioning, that's race, color, religion, marital status, orientation, primary language, immigration status, sexual orientation, gender identity, disability, age, and then source of income, how they're making their money. You want to be careful of those things, right? And the city of Mountain View, I don't know if everybody knows, but the city of Mountain View does have a third party sort of nonprofit available to tenants that focuses on fair housing discrimination. So that does exist, and I'm pretty sure landlords, if you have any questions for them, they're also available as a resource for landlords. And that's through Project Sentinel. And we can connect you with them if you have questions about a situation or general questions. All right, rental agreements. Okay, so leases, highly recommended. Some people do not use leases, but leases are very important because it is a contract between you and your tenant, and it should provide very specific information in it. So it should, you know, definitely state the term of the lease. So some people do month to month, some people do fixed lease terms, 1 year, 6 months, whatever it is. It should list you as the landlord, and then it should put who, where, when to pay the rent. It should be specific about rental amounts, which include utilities. There's a lot going on around utilities right now. So if you're making a new lease, you want to be very specific about your utilities and state which utilities are included in your rent. So if that's water, sewer, trash, you want to make sure to put all that in there. I will be getting more into utilities in a second if that question is about utilities. Um, the other thing is security deposits. You want to list that in there. If subletting is allowed, that's very important and it comes up a lot for tenants. So if you don't want your tenant subletting, be very explicit about that in your lease. Any other fees that may come up, late fees or late payment in rent, things like that. There are a ton of disclosures that should be in your lease, and I would encourage you, if you have an account with like CAA, the California Apartments Association, they have some pretty good templates for all those disclosures, like Megan's Law or asbestos or whatever, lead paint, whatever it may be. You can just grab that from their website. It's very helpful. If you have house rules, quiet times, things like that, you want to just put that all in there. The other tip I have very specific to Mountain View and rent stabilization is if you have items that a tenant can opt into, I would put that in as a lease addendum. So, for example, so like a menu of options. If you get a pet, it will be $50 more a month with a $200 pet deposit. List it very specifically. If you want an extra parking space, it is X amount of dollars a month. Storage would be X amount of dollars a month. Because that is sort of a way to include it in the lease where if the tenant wants to opt in or opt out of it, they can, and we won't necessarily consider it a rent increase because it's listed under what potentially could be rent. Um, you could find yourself in a little bit of trouble if you don't put it on your lease and then you try to add or charge the tenant for it later, it could be considered a rent increase above the allowed amount. So we're encouraging people to just sort of like have a template and include that in all of their leases moving forward, like a menu of services that people can opt in or opt out of um, during their time leasing with you. So I think that is my big tip for leases. All right, yeah, and this is just sort of general that tenants cannot waive their rights through signing of the lease. So regardless of what you put in your lease, if it is definitely outside of the rights that the tenant has under the law, they can't waive their rights away. Okay, during tenancy, rent, and this is where we'll get a little bit into utilities. So see if I answer your question. Okay, what's included in rent? So we have the what we call the base rent. So that's the initial rent when the tenant moves in. And again, that should include any of your fees that you are going to be charging, parking fee, pet fees, utilities, storage, other housing services. And again, if that tenant doesn't want some of those things, I would still include it in that menu option of prices. So in case they do want an extra parking spot or to get a cat, that the option is there. Okay. And then the next thing to consider when talking about rent is any allowable rent increases. And there's a couple ways to increase rent. First and most easy is the annual general adjustment, which we call the AGA. And that is just the allowed percentage every year that gets released to the public around, we released the information around summertime, but September is when it goes into effect. The next is a petition process. Again, landlords can petition the city to increase rent above the allowed annual increase. And finally, banked rent increases, where if you have not given some rent increases in the past, you can hold on to them and apply them all at the same time. Deposits are separate. They are not included in rent. They are a separate entity. So within the security deposit, it could include a pet deposit. These are not rent and they cannot be increased during tenancy. So whatever the deposit is going in is what you have as the deposit going out. And you can use that deposit at the end of the tenancy for things like unpaid rent, damage to the property, cleaning fees. So that's sort of what your security deposit is for. This is the utilities page. So it's broken up into two. I don't know how easy that is to read, but on the left side, we have information about new tenancies. So any tenancies that started March 1st of 2024, um, utilities billed through a ratio utility billing system like Conservice are no longer allowed. You need to have wrapped the cost of utilities into the tenant's rent. So the tenant will just have one fixed price. That price will include utilities, and then every year you can just increase that fixed price by the allowed rent increase amount. And again, the rental agreement, so your lease, needs to be very specific with your utilities. It needs to state the total amount of rent and specify the types of utilities and housing services that are included: water, garbage, sewer, trash, pet fees. You don't necessarily need to break it down by how much, each of those is contributing to the rent, but it just needs to be clear that those things are included in that total cost of the rent. Yeah. And then looking to the right side here for existing tenancies, so tenants that were in there before March 1st, 2024, um, you will continue to use your ratio utility billing system um, until you go through the utility petition process that you are probably either already have worked on or are currently working on with the city. So we do have regulations about that. That is chapter 13, and you can read that for more information. Utilities for existing tenants. So if you have vacancies or you have newly rented units since March 1st, 2024, those utility charges should not be allocated to the existing rental units through RUBS because those tenants, in theory, will already be paying for their utilities because you've incorporated that in their rent. And other utilities that are paid directly by the tenant to the service provider will continue as they always have. So that's mostly going to be PG&E, because they're sub-metered. So that's sort of a general overview. We do have a very big deadline coming up for properties that are between 6 and 20 units. Your petition with the city must be filed by the end of this month. So September 30th is your deadline. The process doesn't have to be complete, but you would have at least have to have submitted your full packet to the city. And then the city will work with you to do all the tenant noticing and get to the final point where you can adjust the rents. But you need to have a complete packet, the complete petition submitted by the 31st of this month, the 30th of this month. There's 30 days in September. Okay. So I'll tell you at the end of the presentation, but there is a workshop specifically on utilities because I don't want to spend that much time on it here because there's a lot of information to get through today. But there is a workshop on the 18th, Thursday the 18th. So if you are interested in that, definitely sign up. Okay, so the one-time utility adjustment petition, just high level, is a petition that is incorporating your ratio utility billings system utilities. So anything that you're charging through RUBS, it's incorporating that into the tenant's rent. So it will look at the physical space rent and the separate utilities, combining those together to get a total rent. So if you need help, our staff is available. Excuse me. Okay, so now just looking at rent sort of in general, again, we have the base rent. So if you had a tenant that lived in your unit on or before October 19, 2015, you needed to have rolled their rent back to reflect whatever they were paying on this time. Or if they moved in after that, again, their base rent is just their initial rent at the start of their tenancy. And then I wanted to go a little bit into some new laws that just went into effect that affect rent and how landlords should be looking at their rent. So we have AB 2219, which has been in effect for a little while, but it just says that landlords should accept third-party payments of rent. So if a third party is going to provide some rental assistance or deposit or first month's rent type of payment, they'll make it clear that they are not a tenant there, but they are assisting with the payment. And as a landlord, you should accept that. In Mountain View, a lot of that may come through an organization called CSA, the Community Services Agency. They do a lot of rental assistance and are very helpful to tenants. So next we have AB 2747, and this is new. This is just went into effect January of this year. And this has to do with rent reporting. So a tenant can request that basically opting into an on-time rent payment reporting to a credit bureau. And a landlord has to do that, and they can charge the tenant the lesser of actual cost or up to $10 um, a month for that service. This is not considered rent. This is not a rent increase if the tenant opts into it 6 months into their tenancy. So you would just do this sort of outside of the scope of rent, but a tenant may ask you for this service, and is now part of the law. All right, so there's also SB 611, which bans junk fees. So that's fees unrelated to rent, like extra charging for the type of payment the tenant is providing, like personal checks or unnecessary type of service fees. Those are no longer allowed. All right, so a little bit more about rent, and then I'll stop for questions. Rent increases, generally speaking, you have to wait 12 months between each rent increase. You have to be in compliance with the law, so fees paid, registered with the city, no code violation, and then again, you must give that 30-day notice as required by state law. The current annual general adjustment is 2.7%. That is new, so that just went into effect September 1st, 2025. So some people may have given a 30-day rent notice in August, and they may have some rent increases coming up for their tenants. So that is perfectly okay. And then sort of just a list of previous allowed rent increases. So if you're planning to bank any rent increases, let's say you didn't use 2024 2.4% and you're combining it together with the 2.7%, that is a-okay. You can do that. So the only thing that kind of limits banked rent increases are it limits up to 10% per year. So if you have a big stack of banked rent increases that you haven't given, then you kind of need to break that up. So because we did have a couple of years with pretty high rent increases with the 2022 5% and 2023 5%. So if you haven't given a rent increase since before 2022, you're gonna have to break that up. So only 10% per year. And then the other important thing to know about banked rent increases is that um, they do not continue on with new ownership. So if you're a new owner, you do not get to keep the rent increases from the previous owner. You start your own rent history as you purchase the property. We do provide a form for banked rent increases because there is some required language about rent increase limits, and the potential to file a hardship petition for tenants, which we'll talk about also. But anyways, there's just some required language on there, and we have a form on our website where you can just use the form. It's easier. Okay, so we do have, again, just noticing requirements. So 30-day notice for rent increases, and there's only one rent increase per month. And if you're doing a banked rent increase, again, it's still 30-day notice. However, you are required to submit a copy of banked rent increases with the city, and you can do that through that online portal. You don't have to submit notices for your regular rent increases, but if you're including an older rent increase, then you submit a copy of that with the city. All right, so when can rental units be raised to market rate? Upon voluntary vacancy. So if a tenant leaves the unit and you're getting a new tenant to start renting, the new tenant starts at market rate. If you have a situation where there was a little bit of a revolving door of tenants or roommate replacements, um, as long as any of the original tenants on the original lease remain in the unit, um, you have to follow the allowed rent increases. However, if people are swapping and no more of the original tenants remain on that lease, you can negotiate back to market. So it's not super common, but it's good to know. All right, let me see if I'm at a good stopping. Okay, almost at a good stopping space. Okay, so who is allowed to live in the rental unit? So we do have a chapter, I think it's chapter 9, where it talks about um, who can be added to the tenant's unit. And so tenants can add in eligible family members. We do have a form that needs to be filled out by the tenant and given both to the landlord and the city. So they can do that, and that would be just immediate family. So that would be like parents, siblings, children. Um, so if they need to bring them into the unit, they can notify you and then give a copy of that notice to the city within 10 days. Again, what I was kind of just talking about before, there is also allowed replacement units, and this is a 1-for-1 replacement. So just if one tenant's moving out, they can swap them for another tenant moving in. The same notice is required for the landlord and the tenants. And if that roommates moving in, landlords can do like a background check to make sure they're safe. If that roommate is paying rent, you can do a credit check to make sure they can afford it. So you do still, can make sure that person is appropriate to be in your unit, but the tenants do have some rights to bring people in. And then again, just be very specific about your wants and needs for subletting or adding roommates other than those allowed above. Okay, I'll stop here and see if any hands are raising or questions are asked. And, and I'll ask you to unmute Kay Wang.
Hello, can you hear me?
I can, yes.
Okay, perfect. I have a few questions. So whenever we add a new person to the rent, are we able to increase rent, like from going from one single person to 4 people? And for paying for all the utilities like garbage and water and things like that, is that an allowable rent increase?
So if that first person, that original tenant is on the lease, then no, you wouldn't be allowed to increase the rent any more than just those allowed percentages each year.
I see.
So,
Even if for paying for all the water and utilities and stuff like that. And with
right,
4 adults, it's different than one adult, but that's not allowed.
no.
Okay. And then the other question I had was, regarding rent increases, I'm just confused. Can we email those rent increases, or does it still have to be like delivered in person or through mail?
What I would recommend is to do it, either in person or in mail. But then you can also always do it as an addition in email. There's sort of maybe a way where if you're mostly always communicating with the tenant through email, then it
Yeah.
may be okay. But I think, just to kind of well, be on the safer side, it's safer to be sure to also post or mail it.
I see. So just the email is really not enough.
Yeah, I wouldn't rely just on email.
Okay, thank you very much. Those are my two questions.
Thank you. Gary?
Hey, Andrea, I have
Hi.
a very similar question. This is Gary again. Um, you had the prior slide, which was regarding like, additional family members joining in these type of things, right? So,
Yep.
very similar to the utility thing, right? Where water is like on 1 meter for everybody, and you increase the number of people, you're going to use the amount of water. Is there any rules or regulations within the city of Mountain View that dictates the number of people that can live within a certain rental unit? So let's say, for example, I have a 2 bedroom, 1 bath, unit. Can I dictate that unit can only be occupied by 2 people, or you know what I mean? How does the multifamily, members eligibility come into that? So if can you tell me how the city handles that?
So it's a state law about how many people can occupy a space, and it is an equation about square footage, but sort of like the general equation is 2 people per bedroom plus one for like the living room area, So that's sort of the general equation for it. Um,
Okay.
if
So
I'm
so
honest,
so and
I have heard other opinions from their lawyers saying that, that's sort of loose and there's ways to kind of argue outside of that, but that's sort of the general rule in California.
okay. Okay, and that's a state, and that goes back to the state.
That's the
So there's
state
there's like there's
law.
like these state laws, and then there's kind of like the county laws, and then there's like these like
Yeah, so
city laws, and they're very different.
our law
Yeah.
is quiet on it. So we do not talk about it at all in the CSFRA.
Okay.
So since we're silent on it, it just refers back to the state.
Okay. That is good to know. Thank you so much.
Yep. Okay.
Sorry, this is Kay again. One additional question. You mentioned the menu of prices, so
Uh-huh.
cannot add additional person fee on that menu? Or is it allowed if we put it on the lease that, if you're starting with one person, this is your rent, but if you're adding additional people, your rent per person could go up?
I mean, I think that would be reasonable. I think that would be reasonable to
Oh,
add that on the menu. And the at the end of the day, the option is always to just either for the tenant to not add anybody else or for the landlord to not accept anybody else. If it's an eligible where it's allowed here, that wouldn't be in the same scenario. So in your scenario, what I'm thinking you're talking about is more like, maybe there's one person who lived in a unit and they want to bring in a roommate that is
oh,
not
and the
considered an
boyfriend.
eligible family member and is not a replacement roommate, is a brand new addition to the lease.
Okay, thank you.
Yeah. So I hope that made sense. That it would be something separate from eligible family members or replacement roommates. It would be a new person coming in. Okay, cool. So we will talk very briefly about petitions. Um, and I'll be honest, most of each topic that I'm talking to you about, we have a whole workshop on each topic. So I'm trying to cram in as much information and not go too far over an hour as humanly possible. So petitions in the city of Mountain View, there's a way to adjust rents either up or down, depending on the type of petition filed. So we have petitions for upward adjustment in rent. So that's increasing the rent more than just what the annual allowed rent increase percent is. And that's specifically a landlord petition. And this is not looking at a per unit basis. This is looking at a property wide. So if you're unable to maintain your net operating income year over year, and your expenses are just getting too big, and your sort of revenue is getting much lower, you may find yourself in a good position to file an rent adjustment petition for your property. And we have a specialist in our staff who can sort of help walk you through that and tell you what you need to collect and how to go through the whole process. Separately, I think one of our questions are also answered here. There's a joint petition where you can add additional housing services, or if you want to do improvements or modifications that are requested by the tenant, you and the tenant together can do a joint petition. So we've seen this where like a tenant wanted to have some sort of, now I'm blanking on one, but like a tenant wanted to have an improvement in their unit, but it was going to cost money. So through the joint petition, both the tenant and the landlord can agree that this service is going to be added, but it would increase the rent by X amount of dollars. I know we had somebody thinking about doing it for electrical vehicle chargers to add them to their property. So that was an interesting one. And then if you don't have in your list of menu options for additional occupants that aren't either the eligible family member or the replacement unit, you can do the joint petition with your tenant, but I think it's reasonable to just add that in the list of menus, and you don't have to go through the petition process. So it saves you and the tenant time to put things in the menu. Okay, so separately from upward adjustment petitions, there are downward adjustment of rent petitions, and these are initiated by your tenants. And so the main ones would be unlawful rent. So if they think that they've received rent increases that are above what's allowed, they can file a petition for that. If there has been some sort of failure to maintain the property, if there has been a decrease in housing services, like a removal of a washer dryer, removal of a pool, removal of a gym, they can file petitions for that. And then also if there is a banked rent increases that they don't think they can afford, they can do a hardship petition, which would delay those banked rent increases from being applied to them. Now, in general, petitions, you must first file the forms with the city. If you need help, city staff will always be able to help. And then it will move forward to a third-party hearing officer who is familiar with rent stabilization, who's very familiar with Mountain View's rent stabilization, and does have a law degree. And they will review the evidence, and they will review the petition, and they will come up with a written decision. So either maybe, yes, you're allowed to increase the rent by X amount for these tenants because of XYZ, or in this case, for a tenant petition, the rent must be reduced, maybe until the habitability issue has been solved. So the hearing officer will make the written decision. If either party does not agree with that decision, they can appeal that. The appeal is heard by our rental housing committee, and a new decision will come out for the appeal. After that, if anybody disagrees with it, then it goes off onto the courts, and people have to go that route. But we do have a lot of petitions that kind of flow through our office, and reasonable outcomes, I'll say. Okay, and then feel free to just sort of raise your hand as I go through this if you have any questions. But we'll just jump right on to the next section. I will quickly take a sip of water. Okay, habitability. So generally speaking, habitability, we have big state law and then more sort of specific local laws that provide clarity and detail about the state law habitability standards. And we'll go through those here. So there are certain responsibilities for tenants and certain responsibilities for landlords when we're talking about habitability, but generally speaking, when we think about habitability for properties, it's that it's healthy and it's safe. So as far as your tenants, um, they should know that they should take care of their units and any of the common areas. If an issue arises, it is the tenant's responsibility to timely notify the landlord. The faster you know as the landlord, the faster you can fix it, and the less damage will be caused. So the tenant is responsible for letting you know as soon as they know. And then they are also responsible for any damages that their guests, their children, their pets are causing. So for our landlords, it is your responsibility to make sure everything is healthy and safe. So if an issue comes up that maybe the tenant caused, you do want to fix that because you do need to provide a healthy and safe space, but you are able to charge back the tenant for those repairs or those damages. All right. Yeah. Okay. So things that we're considering when we're talking about habitability is, working, plumbing, and gas. Being able to get hot water. Excuse me. Um, Properly structured roofs and windows and walls. So we don't want any major damages or anything, balconies that may be shaky. So we want to make sure that that is in good condition. No vermin or garbage around the property. And if there are, be sure that you are documenting your efforts in clearing up those issues. Properly locking doors and windows. So obviously your exterior doors should be locking, and then your exterior windows that people could enter and exit from should be able to lock. Your unit should be having electricity and should be having heating. There also, if you have a multi-unit property in Mountain View, we do have a separate department that does inspections on a rotating basis. It's supposed to be every 3 years, give or take. That's the multifamily housing inspection department. So you may know them, but if you're new, you can expect them to show up at one point. They will schedule a time to come and inspect your property with you. All right, so general kind of recommendations for landlords is to perform a walkthrough inspection and an exit inspection. And this is less now of a recommendation as it is now required as of July 1st, 2025. As a landlord, you need to do an inspection at the beginning and the end of your tenancy, and you need to take photos of the condition of the property. Photos is explicitly stated in that law, so be sure to take photos. And a checklist is great. Videos are also great. This again, now is back to recommendations, but you can put in your lease that you're requiring renters insurance. So that's something that is generally affordable for renters and, can be a good idea for the landlords. And we also have a mediation program in Mountain View that's free for anybody who does business or lives in Mountain View, so tenants and landlords. It maintains the relationship between tenants and landlords, and it is a pretty quick turnaround. We have trained volunteer mediators, and they can help people kind of sort through any issues that they may have face to face. So it's great for tenants and landlords, but it's also great if you have two tenants that don't get along to have your tenants go to mediation. Neighbor issues, they can be a big deal. Okay, now as a landlord, and especially thinking about habitability, sometimes you need to go into the tenant's unit to do a check, especially if it's like the annual check for the fire detector, smoke detector, CO2 detector, whatever detector it is you're checking. So if you do that type of inspection on your property, you want to make sure you do it lawfully. So only enter for necessary or agreed repairs or services or allowed inspections. So again, also like if the housing inspection department's coming, you just need to notify the tenants if they need entry into the unit. So you must give 24-hour written notice, and it should state the time, the date, and the purpose for the entry. Obviously, if there is an emergency, you cannot give 24 hours. So if there's a fire or a flood, let's knock on wood, hopefully no earthquakes. But yeah, then you wouldn't have to give 24-hour written notice. And for your scheduled entries, they need to be done during normal business hours. And the tenant does always have a right to be present. They don't have to be, but they can be if they choose to be. So if your tenant chooses not to be present, and actually if they choose not to give you access after you've given all the required notices, that is a lawful reason to give them a termination notice. But first you must give them a notice to cease, which is just sort of a warning saying, hey, on this date at this time, I told you I was coming into the unit. You did not grant me access. If you do this again, I will be issuing you a termination notice. So that is an allowed reason to go down that route with your tenant if they do not allow you to enter the unit lawfully. All right, speaking of termination notices, in the city of Mountain View for CSFRA covered units, we have just cause eviction protections, which means there are only 9 specific reasons to terminate a tenant. We break these down into tenant cause versus landlord cause. So for the tenants, like something the tenant does to cause the termination, failures to pay rent is number 1, breach of the lease, causing a nuisance, any kind of criminal activity, and again, failure to give access. And you'll notice the bottom 4 have the asterisk next to those. For those, that notice to cease that I mentioned is required before you give the actual termination notice. And you just want to be very specific with your notice to cease about time, date, circumstance of what happened. So be very clear. Okay, and then so on the other side, we have what we like to call landlord caused reasons, or you know, things that the tenant didn't do anything wrong that they're receiving the termination notice. So there may be some instances where there are repairs necessary that require the tenant to vacate temporarily, but still for a time of maybe over 30 days. Maybe there's an electrical issue or a balcony issue, and they have to just go for a short time and they can come back. You're allowed to do an owner move-in, withdraw the unit from the rental market. That is your right. And if the property is being demolished, obviously the tenant would be needing to move. So for any of those landlord caused reasons, we do have a process for tenant relocation assistance. Tenants do have to income qualify. If the unit goes back on the market, they would have the right to return to that unit. So it's very specific. If you find yourself in that situation, I would come and talk to me and I will help you through that. I want to keep this pretty high level because it is a lot of information already. But if you find yourself giving a termination notice, the tenant did not leave, then the only way for you to get that tenant out of your unit is to go through the formal eviction process through the court. So in our case, that would be Santa Clara District Court. So you'll see step one, which you have already done. You gave the tenant the notice for termination. You supplied a copy to the city because you must. And then you go on to serve the unlawful detainer paperwork. That's your court paperwork. The tenant can file an answer to that if they disagree with what you are claiming. They have 10 days to do so. 10 days not counting weekends or holidays. If the tenant does file an answer, so if they do answer back, then a court date will be set, heard by the judge. The judge will issue a judgment, either yes, the tenant has to go, or no, the tenant does not have to go. If the tenant does have to go, they will issue a sheriff's notice. So the sheriff then comes out and puts that eviction notice on the door, and if they must, can escort the tenant out if the tenant still doesn't leave. However, if you go and you serve your court paperwork and the tenant does not file an answer, so they just ignore the paperwork, it will skip the court process and a default judgment will be made by a judge. Most of the time, that results in the sheriff notice because the tenant did not provide their side. So that's sort of the flow of the eviction process through the court. I always recommend, if you're a landlord, to have legal counsel at least help you draft your AUD, because if you get it wrong for whatever reason, it'll slow you down and you'll have to restart and reserve. Okie dokie. So as I mentioned, the only true way to get a tenant out is through the court process. Any other way is called a constructive eviction, and it is not allowed at all. So examples of a constructive eviction would be changing the locks on your tenant, cutting off the utilities, so it just makes it impossible for them to live there, harassing them, preventing entry, so physically blocking the doors or anything so they can't enter the unit, or if there's sort of habitability issues that you're just not taking care of, so it makes it so they can't stay in the unit, that's not allowed. And by not allowed, I mean illegal. Okay, so now we'll look at the noticing requirements specifically for termination notices. So generally speaking, when you're giving a termination notice, it will either be a 3-day notice, a 30-day notice, 60-day, or in some cases, 120 or a year. Either which way, you want to be very specific on your notice about the reason of the termination. So in Mountain View specifically, you have to, for units covered by the CSFRA, you have to state the reason. So it has to list specifically one of those 9 reasons that you're terminating your tenant. If it is one of those reasons that allowed tenant relocation assistance, you must put on that notice that they have a right to that. And it should also have information for contacting our office. We have a regulation about termination notices and noticing. I think it's chapter 10. So that's always just a good thing to look at if you want more information about that. And anytime you serve a termination notice to your tenant, you must serve a copy to the city within 3 days. And again, you can do that on the website. So before, for some of those 9 reasons, you needed to give a notice to cease, it's like that warning. You have to give a specific time amount on there that is reasonable for the tenant to cure the violation, and then provide them our telephone number so that they can call us if they need assistance. And for the case of 120 days or 1 year, that's when you're actually removing all your units from the rental market. So it doesn't happen as often as some of the other notices. But in those cases, we will go through that tenant relocation process. One other thing I'll mention that's not on this page, but the 30 versus the 60-day termination notice, it's 30 days if the tenants live there less than a year and 60 days if the tenant has lived there for over a year. So that's the difference in your noticing requirements for termination notices. So if they did something to break the lease, but they've only been there 6 months, you can give them 30 days. But if they've been there 2 years, you got to give them 60 days. I just did talk about this, but again, 3-day notice, 30 days for under a year, 60 days for over a year, and 120 or a year if we're looking at that withdrawing from the rental market. Okay, we are getting close to the end, just so you know that I am wrapping up. But I did want to talk about tenant buyout agreements because especially sometimes newer landlords are interested in this option because they might have a different idea for what they want to use the building for than what the previous owner was using the building for. But you are able to buy a tenant out, so it is exactly what it sounds like. It's an agreement between the tenant and the landlord, through which the landlord pays some kind of money or other consideration, maybe like however many months free rent, in exchange for the tenant to voluntarily leave the unit. So it is not a termination notice. It is the tenant saying, I voluntarily leave because I am getting XYZ from the landlord. So that is allowed and it does happen. So the process for that, there is a tenant buyout disclosure form that needs to be signed by the tenant before you guys start negotiating. And it just lays out to the tenant, says this is the process, this is allowed. However, these are your rights. You know, it is voluntary. You can say no. You don't have to do it. So that they're just very aware going into the negotiation what's happening. So if you guys come to an agreement, again, the tenant has the right to refuse that agreement, but you should write it out and be very specific about how much you're going to pay, when you're going to pay it. Some people pay X amount when you sign and then another X amount when the tenant moves out. It's up to you and your tenant how you figure it out. Once you come up with your agreement, you must file a copy or you must, yeah, send a copy of the disclosure form to the city. And I think that's within 14 days of signing. So you have 2 weeks to give us a copy of your buyout information. And then as a safety to the tenant, they have 10 days after signing the agreement to change their mind and rescind that agreement in writing. I have not seen anyone do that before, but it is their option. Usually once the agreement is agreed, they move forward from my experience. Okie dokie. Any questions about anything? I'll just kind of keep flying through unless I see a hand come up. So kind of rounding things out with post-tenancy, once tenants are leaving, security deposits. So again, you can use these things for unpaid rent, damage to the property, any cleaning fees that you may have had to incur. So you want to do the initial inspection, that move out inspection, at least 14 days before the tenant moves out. And remember now with the new state law, you want to take pictures of that process. Then the tenant will move out. You'll do your final inspection, more pictures. I encourage more pictures. And then if you need to charge anything to the tenant for their security deposit, you want to make sure you have an itemized list of deductions. For any larger repairs that are needed, you want to include a copy of the receipt. So for example, in my life, I had to do repainting. And so that costs a little bit more money, so I had to include a copy of the receipt. And you want to get that done and the tenant's money returned within 21 days after they moved out. So that's sort of the process, kind of a lot of information from beginning to end. And there's definitely stuff I didn't even cover. So the biggest thing I would recommend is if you find yourself in a situation that you just come to us. We have a lot of office hours that we offer throughout the week, and then we're available outside of office hours as well if those times don't work for you. So again, we have our mediation program, which I do highly, highly recommend, both for tenant landlord issue and neighbor issues. Um, we can do any kind of referral to our mediation program. So if you're interested, just contact our office. We do also have on our website legal referral resources for landlords. If you're having a hard time finding a lawyer that you want to use, you can sort of log into these websites and kind of navigate around there to see what might best fit your needs. And then as far as our office goes, we have Landlord Housing Help Center every Thursday in the afternoon from 1 to 3 p.m. And that is both online or in person at our office. We're at 298 Escuela Avenue, right next to the senior center. It looks like a house, but you'll see our banner on it. It is a city-owned property that we work out of. And then if you want to join our help center on Zoom, it's mountainview.gov/housing help clinics. If your tenants need help and you want to refer them to us, especially for things like rent assistance, they can come to the Tenant Help Center, which is in the evenings, and that's only the first and third Thursdays of every month. So they can come either on Zoom or in person as well. And we have a staff member from CSA who attends that can talk to them about rent assistance. So it's a good referral. Okay, I did want to mention our upcoming workshops. So we do have that one on September 18th at 2 p.m. about submitting your utility adjustment petition. So if you have questions about utilities, definitely go to that workshop. And then on October 7th at 2 p.m., we have a guest speaker from CSA, the Community Services Agency, that will talk about how the CSA can assist your tenants, especially with things like rental assistance or food distribution services. If you know they're kind of struggling and need additional support, they're going to kind of show you as the landlord how to navigate those services and how to best kind of communicate that with your tenant. So it's pretty cool. Our the rent stabilization division, so our sort of normal contact information is here. Our phone number, our email address, and our physical address. And then we have a ton of information on our website at mountainview.gov/rent stabilization. And then we also hold open office hours every single Tuesday, unless it's a holiday. But otherwise, we're there every Tuesday from 10 a.m. to noon. And you can join us on Zoom. That's Zoom only for these. It's mountainview.gov/RSP office hours, rent stabilization program office hours, RSP. And that is the end. So thank you for kind of hanging in there. I hope I didn't take too long. If there's anybody with any questions, I'll hang around. Otherwise, thank you so much for coming. I will be sending a link to the recording and a copy of the PowerPoint. Also, there will be a survey. So if you want to click on the survey when you get that, let us know how we did. Or if you have any topics you really want us to dive into, we love the suggestions. So thank you so much. Have a great day. All right, I don't see any questions, so I'm gonna go ahead and close this down. Have a great day, everyone.